Good day, Crime Talk aficionados. It is Sunday, which means you are here for the best of Crime Talk throughout the week. The weekly review, all conveniently located in one location. This is for the week of March 2nd, 2026. Enjoy the show. We'll see you Monday. And remember, the Constitution matters.
All right, lawyer.
Perhaps I was maybe wrong about charging adults for the conduct of their children, right? We were talking about the case. We've had several of them over the years. One going on, obviously, in Georgia. We had the case in Michigan, where, of course, it was a shooting. Now, shootings apparently are much more results-oriented when it comes to getting convictions of parents. But wait until you hear this particular case, all right? In a case that's obviously provoked some widespread condemnation, police in Miami have charged two boys, aged 12 and 13, as adults for the alleged violent sexual assault on a 12-year-old girl. Now, according to court records cited in public reports, on February 27th of this year, Nelson Nunez and Josiah Jones, 13 and 12 respectively, allegedly approached the victim, forcibly dragged her into a garden area, pinned her down, and subjected her to an assault of the sexual nature lasting approximately 30 minutes. During the incident, one of the boys reportedly placed rocks in the girl's mouth to silence her cries of, "No, no, stop, stop, it hurts." The assault reportedly ceased when the victim's father called her name, at which point the boys and another witness fled. Now, the decision to charge the minors as adults reflects obviously the severity of the alleged conduct. And there's been a lot of people commenting, including strong calls for the maximum penalties and parental accountability. Obviously, the case is in its early judicial stages with no further procedural details released as of the time that we are bringing you this report, ladies and gentlemen. So, let's see if the bandwagon of charging parents of juveniles when it comes to gun cases will continue when it comes to crimes of violence of this nature. And does it matter the race or ethnicity of the defendants, right? Because most of the school shootings are predominantly white kids. Are they not? At least what we've seen so far. Will they still do the same for these 12 and 13-year-olds and maybe their parents? I mean, clearly one could say maybe these parents shouldn't get the Mother and Father of the Year award, and these young boys are presumed to be innocent indeed. But think about it, ladies and gentlemen. This is what we talked about. And if you're going to do it for one case, I think you then got to start doing it for all the cases. But you could say, oh, Scott, these parents didn't know what these young boys were going to do. Well, do they? Have they been talking about this? Maybe they need to go search the computers, see what kind of parent interaction was taking place. Apparently, somebody raised these two children to think that, after all, it's okay to do this to a 12-year-old girl. And when they're doing it, they're assaulting her to shove rocks in her mouth. Are you kidding me? One could say that was learned behavior. One could say the parents must have taught them that behavior. Maybe we need to go hold the parents accountable. Let me know what you think, ladies and gentlemen. If it's good enough for one type of case, shouldn't it be for all juvenile cases? And this is what I told you. It's a slippery little slope. You want to go down that game? Well, maybe it's just for the cases that, we really feel strongly about. Why shouldn't we feel strongly about a case like this, ladies and gentlemen? Next, how about the verdict in that Colin Gray matter? Yeah, didn't go so well for him down there in Georgia. So down in Winder, Georgia, a Barrow County jury today found 55-year-old Colin Gray guilty on all 27 charges related to the September 4th, 2024 mass shooting at the Appalachia High School, holding him accountable for providing his 14-year-old son, Colin Gray, with an unsecured AR-15 style rifle that was used in the attack. The shooting claimed the lives of students Mason Schemenhorn and Christian Angualo, and teachers Richard Aspinwall and Christina Irmi. Prosecutors presented evidence that Colin Gray ignored warning signs of his son's potential of violence, including photographs of school shooters Nicholas Cruz displayed in Colt's bedroom. Gray testified that he never viewed his son as a threat, despite reports of bullying and occasional rage. The jury deliberated for less than 2 hours before delivering unanimous guilty verdicts on charges including second-degree murder and cruelty to children. Gray showed no visible emotion as he was taken into custody. Sentencing has not yet been scheduled, but the convictions could result in a life sentence. Needless to say, the district attorney, quite proud of themselves, referenced the precedent set by the Oxford high school shooting case in Michigan, noting that proactive parental intervention might have prevented the tragedy. And obviously, this underscores the growing legal accountability for parents in school shootings involving unsecured firearms. But I say don't stop there, ladies and gentlemen. Now, I did tell you yesterday, maybe I'm wrong, with those 2 young boys that did horrible things to a 12-year-old girl, in fact, by putting rocks in her mouth because she was yelling. And it really makes you wonder. Maybe if your kid is just a bad seed, we should just blame it on the parents. Now, what if this wasn't a firearm in the Colin Gray case? What if it was a car? And maybe you knew the kid had a couple of accidents, maybe a speeding ticket or 2. And then one day he goes through and drives into the school and kills everybody as well. Should the parent be held responsible for that too? I don't know. I think it's a slippery slope overall, ladies and gentlemen. You don't want that. And hey, why not stop there? Why not stop with the grandparents too? Keep it going. The next door neighbors. How about the school? How come nobody from the school is ever charged when they could have done just a little bit more? Something to think about, ladies and gentlemen. That's right. The former DeRidder, Louisiana mayor, Misty Roberts. Okay, when you have a first name like Misty, I think you're bound to go to prison. And it's probably going to involve a sexual offense. I'm not sure why, but I think it is. Anyway, Misty Roberts, 43, was convicted last night. We brought it to you on our live show of carnal knowledge of a juvenile and indecent behavior with a juvenile after a jury deliberated for less than 1 hour. That's code for, man, she was guilty. Anyway, the charges arose from a 2024 pool party at her residence where some alcohol had been served to some underage attendees, including her teenage son's 16-year-old best friend. Anyway, testimony established that Roberts engaged in sexual activity with the minor, an act observed by her son through a window crack and by her daughter, who described seeing the pair on top of each other. Additional witnesses included the victim himself corroborating the events, and while Roberts' ex-husband, Duncan Clayton, testified that she admitted to the act and pleaded with him to deny it in text messages. Anyway, prosecutors introduced text messages between Roberts and the victim's mother discussing birth control and emergency contraception, along with the evidence that the DoorDash delivery of some Plan B was made to the home shortly afterwards. Now, Roberts resigned as mayor just days before the arrest back in 2024 and wept upon hearing the verdict, like she really thought she was going to be found not guilty. Anyway, she was released on a $100,000 bond pending sentencing on April 17th, where she could receive up to 17 years. And guess what? She's going to have to register as a sex offender. It's all fun and games until somebody sees you with the 16-year-old, I guess. Anyway, it's even worse when it's your own children and then your husband come testify against you as well. Wow. Can you imagine what Christmas is going to be like around their house? Awkward. Anyway, like I said, the case also involved a prior divorce finalized in 2022 and a contentious custody resolution granting primary residence to the ex-husband in late 2024. Gee, I wonder why. Boo-hoo. Poor lonely Nick Reiner. That's right. Nick Reiner, the 32-year-old son of filmmaker Rob Reiner and producer Michelle Singer Reiner, has received visits exclusively from his defense attorney while he's being detained at the Twin Tower Correctional Facility as he awaits the trial process related to the charges of his alleged killing of both of his parents while they slept. Like I said, he faces 2 counts of first-degree murder in connection with the December 2025 deaths of his father, Rob Reiner, who was 78, and his mother, who was 70, Michelle. The couple was discovered in their Brentwood residence suffering multiple sharp force injuries. That's code for stabbed to death, ladies and gentlemen. Anyway, the Los Angeles County Medical Examiner's Office ruled both deaths homicide, which seems pretty obvious, probably not a suicide. Doesn't sound like an accident. Doesn't sound like, it just was a miraculous burst of, sharp, blunt trauma injuries. No, it was a homicide by stabbing, and homicides are classified as the killing of one person by another. Anyway, Mr. Reiner was arrested shortly thereafter, and he's been held in custody without bail. Now, during his arraignment on February 23rd, Reiner entered a not guilty plea, and he was represented by the public defender, Kimberly Green, who assumed responsibility after the prior attorney, Alan Jackson, withdrew for no money. Anyway, court records indicate that Green is the sole visitor Reiner has received at the facility. Neither one of his siblings, Romy or Jake, have visited him or attended any of the court proceedings. Now, some people would be shocked. Why would your family members not go? Well, maybe it's because he's accused of killing their parents and they believe that he killed the parents. So why would they go talk with him? And even if they did, it's not like they're going to talk about the facts of the case, because they would go tell the prosecutor everything that they'd heard, right? It's probably best, since they're witnesses in the case, not to go talk with him. So, obviously, given the high-profile nature of the case, Reiner has been placed in administrative segregation at the downtown facility. Now, a former sheriff that worked there stated that such protocols are standard in prominent cases to protect inmates from potential harm by other inmates in general population. Additionally, Reiner is also housed in the mental observation unit, as evidenced by his wearing of a specialized anti-suicide gown during the court appearance. Now, inmates in this classification undergo mandatory welfare checks at least every 15 minutes around the clock, and may be kept separate even from other segregated inmates if they deem to pose a risk to themselves or others. Now, Reiner has a documented history of schizophrenia and prior challenges with substance abuse that included multiple periods in rehab. Now, the Twin Towers Correctional Facility, which previously housed other notable detainees, has obviously come under some scrutiny. In September of 2025, the Attorney General, Rob Bonta, filed a lawsuit against county authorities alleging inhumane treatment and inadequate facilities. In response, the Los Angeles Sheriff's Department have allocated $309 million towards staffing, more deputies, infrastructure repairs, and other improvements of the building. Now, Reiner's next scheduled court appearance is set for April 29th. A conviction on the charge obviously could lead to a life sentence. So, I know this is, everybody makes this out to be big news, but, sometimes the SHU, the special housing unit segregation, obviously there's reasons for that. If you have inmates that can't play well with others, they go to the SHU, and they only get out once a day. If they can't be nice to the correctional staff, they go there and get out once a day. They're supervised. And it really sucks for the attorney, because literally when you're in the SHU, there's usually when you meet with your client, there's bars, but there's usually plexiglass up, and you can't pass anything through. Most of the discovery is on computer these days, so it's almost nearly impossible to go over the discovery with your client. Literally, it's about the size of this table here at the Crime Talk studios, and usually have one chair, maybe two, but it's very difficult if you have another individual on your side. And like I said, it's obviously separated. The most important thing that clients complain about when they're in protective custody of the SHU is obviously the isolation. If you're in general population, you get to watch TV. Really, all you can do while you're in custody in the SHU is read books. And it really affects some people. I was actually at the Federal Detention Center today visiting a client, and I saw an attorney. We were, let's just say, we both had a mutual client at one point. And our mutual client had to go to the shoe. And apparently after about a month in the shoe, for lack of a better term, it broke him. And he decided that it's his best interest to ultimately take the deal in the particular case. So the shoe can have some negative effects as well. I wouldn't want to do it. I would go totally stir crazy, maybe read a lot of books. Maybe I'd like it for a little while, but it'd be like going on a vacation more than about 3 days. I'd go totally stir crazy and would want to come back to work. So it's not pleasant. I don't really wish it upon anybody, really. It's not a pleasant experience. People in the shoe, they don't like it, but it's part of the harassment package. Let's just put it that way. Next, Suzanne Morphew. Where is she now? Well, the body of Suzanne Morphew, who vanished from her Maysville, Colorado home on Mother's Day 2020, was recovered in a remote field back in September of 2023, but the remains have remained unclaimed in a morgue for nearly 2 years. Now, the El Paso County Coroner's Office made the remains available to the family in April of 2024, yet no one took possession at that time. And then in late January of 2026, Barry Morphew, Suzanne's husband, who is facing first-degree murder charges, signed paperwork authorizing release to a funeral home for cremation. Prosecutors then obtained a search warrant on February 18th and seized the body the following day, citing its evidentiary value ahead of Barry Morphew's scheduled October 2026 trial. Well, throw in Suzanne's daughters, Mallory and Macy, who have publicly supported their father and are now seeking judicial intervention through their attorney, arguing a violation of the Victims' Rights Act. The district attorney has stated that the family lacks authority to reclaim the remains before the trial. Obviously, Barry Morphew is remaining under house arrest after posting bond in his particular case. The judge has not ruled on the case. And as I have said before, I had a very similar case, a couple of dead kids down in the southwestern part of the state. And it wasn't until all the trials were done that finally the remains, literally the remains of the bones, literally in a box that had been shipped all over the country for independent analysis, were ultimately given to the family members for a proper burial. So yes, the prosecution does have a right to keep the remains if they want to. Now, normally they do not. Usually it's quite obvious, but the defense could oftentimes make a claim that we would have retested it, and this could be destruction of exculpatory evidence. And so I believe the prosecution's trying to protect the record from the defense being able to make that argument.